gens qui vont venir de domaines différents. On va avoir des avocats, on va avoir des spécialistes de la restructuration, on va avoir des financiers. Et tous ces gens-là sont en train de construire quelque chose qui n'existe pas aujourd'hui.
Avec cette association internationale qui crée le Chapter France, on va pouvoir échanger entre professionnels du restructuring et puis on va pouvoir partager des bonnes pratiques.
On est vraiment dans une association qui comble un besoin. Je pense qu'on aura du succès, donc on va voir ça dans les jours et mois qui viennent. Et on espère que tout le monde va suivre le mouvement et notamment tous les professionnels du secteur pour faire de cette association une réussite.
Bonjour à toutes et à tous et bienvenue au 6e TMA Talk. Et pour la première fois, nous allons faire un webinaire en langue anglaise et sur un sujet plus international qui sera une présentation du régime de insolvabilité et de redressement des entreprises en Angleterre ou en droit anglais. I'm going to hand over to our experts who are Emma Gateaud and Richard Tett of Freshfields in London to explain to us all about the English insolvency regimes.
Merci John. Alors je vais commencer. Merci. Je vais commencer avec quelques mots d'introduction en français et puis ensuite on continuera la présentation en anglais. Alors le sujet pour aujourd'hui est vaste et je sais que nous avons 45 minutes, donc on va pas pouvoir tout couvrir, mais nous allons essayer de vraiment couvrir les outils principaux du restructuring, ainsi que de parler un petit peu des procédures dites d'insolvabilité en Angleterre. Et bien sûr, nous allons nous concentrer sur le développement majeur de l'année dernière, qui est le nouveau Restructuring Plan, qui a déjà été bien testé dans la cour anglaise où la jurisprudence se développe. Donc, nous allons nous concentrer là-dessus. Et enfin, pour finir, nous voulons un petit peu aborder les questions de juridiction et d'aspect cross-border. Pour ce qui est des schemes et des restructuring plans qui sont importants post-Brexit. Donc voilà, je vais continuer en anglais maintenant. So here on this slide, you see an overview of all of the, or most of the restructuring and insolvency proceedings in the UK. And as I mentioned, the talk will really focus on the rescue proceedings, so the right-hand side of the pink section. But I think it's probably worth touching on the most distressed areas first. And so liquidation is, if you like, the most distressed insolvency proceeding in the UK. It's really, as the name indicates, a process for liquidating the assets of a company. It involves the appointment of a liquidator, an insolvency office holder, so the directors no longer have any powers, and the liquidator is appointed to act on and owes its duties to all creditors in order to, and the liquidator seeks to recover the assets, realise value, realise the assets, and distribute the proceeds to the creditors. And that is the main aim of the liquidation. It can be, you can start a liquidation from a company straight away going into liquidation, or it can be an exit from an administration. And there are different types of liquidations. Actually, slightly misleading, the first one isn't really an insolvency because it involves a company being solvent. The members' voluntary liquidation is really a corporate reorganisation process. and it involves the directors swearing statutory declarations that they're able to pay their debts within the following 12 months. So the first process, members voluntary liquidation, is started by a shareholder and is a solvent liquidation using corporate reorganisations. The next one, the creditors voluntary liquidation, is one where the directors can't swear the statutory declaration, so it's an insolvent liquidation, and it is again started. It's again an out of court process. It's started by the shareholder resolution. And then finally, you have the compulsory liquidation, which is a court-appointed liquidator. And it can be started by the company, but often is started by a creditor putting in a petition to wind up a company. And interestingly, during this pandemic, the government has introduced restrictions on creditors putting in winding up petitions, unless they can show reasonable grounds that the debts are not being paid by reasons other than COVID. And so effectively there's been a restriction on putting in winding up petitions, and that's been most relevant in the context of landlords and leases, and tenant companies have been protected from landlords putting in winding up petitions to seek to liquidate them. And these restrictions were due to end on the 30th of June this year and have been in place since April last year. And we found out yesterday that these restrictions will continue until the 30th of September. So it gives additional breathing space for all of these companies during the pandemic who are not necessarily paying their rents. And we've also heard from the government that they are looking to introduce new legislation to deal with all of the rent arrears, so that come 1st of October we don't get a wave of liquidations and winding up petitions being put in. So that's a space to watch. But that's the main sort of process for liquidating companies, the liquidation. Then separately, we've got the fixed charge receivership, which is a private remedy for creditors to enforce over set their security over specific assets. So this only relates to the assets secured, and the receiver who is appointed does not take over the company as a whole, really deals with the assets which are secured, and that's a remedy which is contractual and is used very, very often and works well too. Moving on to the rescue proceedings. So the most distressed process is the administration, and that is an insolvency proceeding, and that involves the appointment of an insolvency office holder, an administrator. And it was introduced to be a rescue proceeding, so not a liquidation, to try and rescue the company, and we'll talk about it in more detail. The main advantage of the administration is it provides a statutory moratorium, so it prevents creditors from enforcing their debt or security without the consent of the court or the administrators. And really, in practice, without it being combined with a CVA scheme or restructuring plan, in reality, it's not really being used to rescue companies as a going concern going forward, and it's most often followed by liquidations. However, it has been used very often to effect pre-packs and to be combined with one of the other tools, the other rescue proceedings on this slide. And so the administration is a process which is not debtor in possession, so that the directors lose their powers as well. The last three on this slide, the CVA, the scheme and the restructuring plan, are all debtor in possession processes. So they are all processes whereby the directors stay in situ, and most often the directors are the ones proposing these plans, schemes or CVAs. and they are a means of compromising debt and effecting an arrangement between the company and the creditors. The CVA is part of our Insolvency Act, and therefore it has a little bit more of a stigma of insolvency, although we'll see you don't necessarily have to have an insolvent company to propose it. But the schemes and plans are part of our Corporate Companies Act process, and therefore have much less of an insolvency stigma. Schemes of arrangement can be entirely solvent, and there's no requirement for insolvency or financial difficulties. But the new restructuring plan, which, as I mentioned earlier, was introduced in June 2020, and is our version of, if you like, it's the English answer to Chapter 11, which allows a cross-class cram-down, was introduced last year, and it is also part of our Companies Act, but it does have a slightly higher bar for entry. It does require to demonstrate financial difficulties, as we'll see. Before we delve into the detail of these 3 rescue proceedings, we thought it'd be helpful to draw comparisons with perhaps a French system and point out what the key principles of the UK restructuring regimes are and where they come from. I'm sure you've heard that the UK is historically very creditor friendly, and it's perhaps worth thinking about where that comes from and looking back, if you like, in the 19th century, if you didn't pay your debt, if your debts were not honoured, then you were sent to a debtor's prison, and not paying your debt was equivalent to theft, and a man's word was his honour, and the focus was on ensuring that people respected their contracts and honoured their debts, and that's really the starting point for sort of the focus on the UK system being creditor friendly. And then if you look at the development of sort of 19th century, how the introduction of limited liability companies, and then following sort of influences from the US, and the focus really shifted towards, and it really culminating in the restructuring plan being introduced in the UK, but the focus over the last few years has really been shifting towards preserving the enterprise, rather than just being creditor friendly, and ensuring that the company and the enterprise, the business of the company, continues. And if you think about the origins of Chapter 11 in the US, and really that arising from, as I understand it, building railroads in the US and ensuring that you have a continuation of the business, come what not, and that's really been the focus in recent years in the restructuring regime in the UK. And we've seen, with schemes and restructuring plans, quite significant haircuts being introduced, imposed on creditors, and therefore I think now we can really talk about the UK being much more sort of company friendly regime, although there is still a focus on rights of creditors. What it is not, though, is shareholder friendly. There is very much a distinction between the company and the shareholders. So unlike the French system, it wouldn't describe the English system as shareholder friendly at all. And if you consider the directors' duties for directors in a company, whilst directors owe their duties to the company, and in purely solvent times, the company is represented by the interests of the shareholders, so the directors will look at the interests of the shareholders. the company is a very much a fluid concept, and the law recognises that as the company verges towards insolvency, then the duties start to shift, and the law recognises that the real owners of the company, the people who stand to recover something in an insolvency, are the creditors. And that's where the directors then need to turn their focus to thinking not about how to preserve the interests of the shareholders, but how to preserve the interests of the creditors. That doesn't mean you disregard entirely the shareholders, but there is a recognition that the creditors are the ones who stand to recover assets in an insolvency, and therefore it is their interests that need to be protected. And that whole principle comes across very much in all of our restructuring processes. So in CVAs, schemes and plans, the court will need to see evidence of what the alternative is if the plan, scheme or CVA is not approved. And most often that is an insolvency. It doesn't have to be, but it's very often is in these distressed circumstances. And that insolvency and what creditors stand to recover in that insolvency will be a very important metric and will be the benchmark against which the judge and the court will decide whether it is right to sanction the scheme or the plan or the CVA if the CVA is challenged. So the court will want to know that the creditors are getting are no worse off than in whatever this comparison alternative is. So whatever the insolvency is, and that's a really important benchmark, and the law really focuses on that and ensuring creditors, especially the insolvency delta, is respected. I think generally the UK restructuring regime is very flexible. It's not very prescriptive in what you can use. There's schemes, plans, CVAs can, a company and its creditors can agree whatever they want, be it a small amendment, a waiver, or a full debt for equity swap, full write-off, etc. So there's a lot of flexibility, and you can combine tools. So you see administrators presenting CVAs or schemes, or potentially in the future plans. So there's a lot of flexibility in what you can propose as a solution. And finally, I think that the courts are very, very quick and commercial. If you can demonstrate urgency, the court process can be very quick. For schemes or plans, you can go through it in a matter of weeks or months. So I think I'll move on to the detail of the rescue proceedings now. So what's a scheme of arrangements? Really, this is a process, as I mentioned, it's part of the Companies Act, and it's often used for corporate reorganisations for altering the rights of shareholders. So it can be a scheme between a company and its shareholders, but it's also been used over recent years to alter the rights of creditors. So it can be any compromise or arrangement between a company and its creditors and various classes of its creditors. It can be proposed by creditors, but in practice, it's mostly proposed by a company. It can be used to bind secured and unsecured creditors, unlike a CVA, and it's not an insolvency process, so it doesn't have the stigma of insolvency, and can be used. In fact, even schemes of creditors can be used for entirely solvent companies. So it involves two court hearings. There's a fair bit of disclosure, explanatory statements, rather like a prospectus that need to be distributed to creditors in advance. The court is not there to rubber stamp, has a very detailed look at the procedure and fairness on the scheme. So there's a first court hearing for convening the meeting of creditors. Then there is a meeting of creditors or various classes of creditors in which they vote to decide whether to approve the scheme. And then finally, then the court then looks at, there's a sanction hearing in which the court decides whether all of the procedures have been followed correctly and whether the scheme itself is fair and can be sanctioned. So creditors vote in classes, and the really important thing to remember for schemes is that all classes need to approve. Unlike in the plan, which we'll talk about shortly, in a scheme, unless you have every class approving, the scheme will fail. And classes are decided by the company proposing, or put forward by the company proposing the scheme. And creditors are organised according to their rights currently under their existing documents. Are their rights so similar that they can consult together as part of a scheme? And also you'll look at the rights within the scheme and what the scheme does to their various to the documentation and their debts. So both of these factors will need to be considered and tested in order to decide what the classes are. And the court will look at many factors such as fees. Are any of the creditors locked up? Are they receiving any, etc. So there's many factors looked at in the formation of classes. And each class, in order to approve the scheme, must have 75% in value of creditors voting in favour and a majority in number. So those are a head count of creditors present and voting. So it's 75% in value and majority in number of those creditors voting. So you don't take into account the votes of those creditors who are not voting. You don't take into account the value of the creditors who are not voting. So that is schemes, and they've been used for, as we'll talk about later, for UK companies, but also for foreign companies. So these are the schemes that have been introduced and sanctioned in the past year or so, since June 2020, since the introduction of the restructuring plan. And this is just to show that actually the introduction of the plan hasn't yet been the death of the scheme, although it's very similar to schemes. Schemes are still being used. And that may be in part due to the fact that the plan was a new tool and hadn't yet been tested. So it may be, and we've seen more and more plans come through since last November, and it may be that gradually plans do come to take the place of schemes more and more. But there are some differences, which means that schemes could still have a use going forward and may not entirely be replaced by plans. So company voluntary arrangements, as I mentioned earlier, are part of our Insolvency Act, but don't require an insolvency. And they are a means of compromising unsecured debt of the company. So whilst a scheme can compromise secured and unsecured debt, these CVAs can only compromise unsecured debt, which means that traditionally they've been used really to deal with very often rent liabilities, so landlords, CVAs. And importantly, they're they've traditionally been seen as much cheaper and quicker than a scheme, because they don't involve any court process. So if they are not challenged, they don't involve going to court. It's simply an arrangement, a proposal made by the company to all of the unsecured creditors. And there are no classes. All creditors, all unsecured creditors vote together, and there's entire flexibility as to what you propose. Again, like a scheme, you can propose anything, and the requirement for voting is that 75% in value of the unsecured creditors vote in favour. So even those creditors whose rights are not being affected still are entitled to vote. And even secured creditors can vote to the extent of their unsecured portion of the vote. So traditionally, it doesn't require a court process. However, creditors do have the ability to challenge a CVA, and we've seen a number of challenges recently. We've seen the New Look CVA and Regis CVA being challenged last month. And these were both landlord CVAs with lease liabilities being compromised. And the two grounds for challenging a CVA are, one, that there is a material irregularity, and so that could be, for example, that procedures not being well followed, disclosure information's not being given, or two, that there has been an unfair prejudice. And the court there will look at ensuring, as I mentioned earlier, that one, that creditors are not being treated in a worse way than they would be in an insolvency, if insolvency is the alternative, if the CVA didn't go through. So that's what we call the vertical comparison. So are creditors, unsecured creditors, getting more than they would do in an insolvency? And then there is a horizontal comparison, and that's looking at the treatment as between different categories of creditors. So although we have one class really of unsecured creditors, there isn't a division between classes. All the unsecured creditors in a CVA vote together. The court has recognised that it is possible to treat different categories of creditors differently. So, for example, in landlord CVAs, it's common, and we saw this in the New Look CVA, to divide the landlord leases into different categories. You have the A category, the B category, the C category, and each category will be treated in a different way. So, for example, the A leases will be the ones that are the most profitable, and they will be the ones which, for example, in the New Look CVA, whose lease liabilities weren't compromised at all. And then the Bs and Cs, etc., or less profitable CVAs where actually leases where actually the lease liabilities were fully released, the rent arrears were fully released going forward. And the court recognises that it is possible, and the New Look CVA went through and was approved despite the challenge. It is possible to treat different creditors differently, so long as the differences in treatment can be justified. And then compare that to the Regis challenge, which was also recent, and again a landlord CVA. And there the challenge was successful, and the CVA didn't go through because one of the reasons was that there was an unfair prejudice, because one of the unsecured creditors, an intercompany debt liability, was not being compromised, and there was no justification for that compared to all of the other unsecured creditors that were being compromised. So if challenged, a CVA in court, the court will look very closely at the treatment of the creditors, both doing the vertical and the horizontal analysis. And just to one last point on this slide, the CVAs can be used in combination with an administration. So, for example, we've got the example here of the Nortel CVAs, and they were presented by administrators. And in fact, there were a number of there was a French company in administration in the UK which also put forward a CVA, and that was used to ensure that there were bar dates for claims and to ensure an orderly distribution in the administration. So there are many uses to CVAs, and they can be used with foreign companies. And finally, the exciting new tool. So it's called the Restructuring Plan, but it's been referred to as a super scheme, or the UK's Chapter 11. And essentially, it uses the same procedures as schemes. So like with the scheme, you have a convening hearing and a sanction hearing. You have creditor and shareholder meetings. You have classes of creditors and classes of shareholders according to similarity of rights. And again, the company has a full flexibility as to what it proposes to its creditors or members. And it's available for non-UK companies, provided they can show that they have sufficient connection, just like with a scheme. But unlike a scheme, in order to approve it, the requirement is only a 75% in value requirement. There isn't the headcount or majority in number requirement of the scheme. So it's an easier threshold to meet in each class. But the most exciting feature is this cross-class cram down. So whereas in a scheme, every single class needs to approve, the plan can be approved, and it's discretionary, but can be approved by the court if one class approves it, and even if all other classes vote against, if certain conditions are satisfied. So the first condition is that the class approving it has a genuine economic interest in the company, in the relevant alternative. So is an in the money class, if you like. And the second condition is again back to this concept of ensuring the creditors are no worse off than in the relevant alternative. So the company will need to present to the court evidence of what the relevant alternative is if the plan isn't approved. And in all of the plans that we've seen so far, and you see some of the logos on this slide, the relevant alternative has been an insolvency, whether it's a liquidation or an administration. And the court will look at evidence of what creditors stand to recover in that alternative. And the company will need to demonstrate that the plan provides a recovery for creditors, which is no worse than in that relevant alternative. So they're the two conditions. And actually in Virgin Active, you saw that actually the plan itself was ensured that the landlords received 120% of what they would have received in the relevant alternatives. So it's very much based on ensuring that they get a better result than the relevant alternative. And just the final point before we move on to the examples, with a plan, there are two options for dealing with classes that are out of the money or shareholders. One is to exclude them, to allow them to vote, as we say. So we could have a class of shareholders voting and a class of creditors, and allow the creditors, for example, to cram down the shareholders, or the senior creditors to cram down the junior creditors. But if there is clear evidence that the junior creditors or the shareholders are totally out of the money, it is open, and the legislation allows that, for the company to demonstrate to the court that that class is entirely out of the money, and to be excluded from the voting and still be bound and affected by the plan. So there is that option in the plan to either allow the class that is out of the money to vote, or to exclude them entirely and ensure that they are bound by the plan. And we've seen a number of examples already of the restructuring plan, including a Mauritius company, Smile Telecom, so non-English company. And I'll now hand over to Richard, who'll take you through some recent examples of the restructuring plan.
Many thanks, Emma. And if we go on to the next slide, I'll take things quite quickly now, if that's okay, so that we have to allow enough time for questions at the end. We've got some great questions that have come in already on the chat, so please do sort of type away and we will pick those up in due course. So, as Emma said, the new restructuring plan, which came in almost a year ago, so just under a year ago, was really a major shift for UK restructuring regime. The ability to have cross-class cram down, which you have in France, which has been the case in the US for a long time, we have it in Germany, Spain, Italy. This was really quite a major move forward from us. Before, in a scheme, every class had to approve. So in the capital stack that we have there, the junior and the senior secured and the equity, this is just a sort of stylized simplistic. In a scheme, you would have had to have each one of those classes approving by 75% by value, majority by number. So what people would traditionally do then is they would use maybe two different techniques. You'd have the company voluntary arrangement to maybe compromise the unsecured creditors and the landlords, and you might then also use a scheme to do the secured debt. And that was time consuming and expensive, and was something that was really frankly only good for the advisors who were running the processes. So, but the plan now enables you to do much simpler, much quicker, whereby if, as Emma said, 3 green lights need to go on to be able to use it. The first is you need 1 class to approve. You can have 20 classes, you only need 1 to approve, and that green light goes on. And that's 75% by value of those voting. The second green light, as Emma said, is that the other classes are treated no worse off than the relevant alternative. So you have to work out what that relevant alternative is, probably an insolvency, work out what they would get in that scenario. You must give them at least that much, otherwise it's unfair. So first green light, 1 class approves, second green light, all the classes are no worse off than the relevant alternative. And then the third green light is that the court, in its discretion, considers that it's fair. And that opens up quite a wide range of arguments that can be made. So in Virgin Active, which is the really at the moment is the leading case on it, there was senior secured debt. That was the class that approved. There then were several classes of junior creditors. Different landlords were treated differently. One of those classes approved, but the others did not. But the court could cram them down. The court forced the deal on them, despite the fact that very few of the people in those classes supported. So if we move on to the next slide, onto slide 12, what we have seen to date in terms of restructuring plans, the way it's been used, one of the possibilities is that there's no absolute priority rule in the English regime. So you could have junior creditors imposing a, quote, term out on the seniors. So extending the maturity and amend and extend could be forced on the seniors. That's yet to be seen, but that's a possibility. Forcing a deal on the junior creditors, where they recover only a small percentage. In the Pizza Express, which is a chain of pizza restaurants, as the name suggests, there the senior creditors imposed a deal where the juniors got just a little bit of the equity, very small single-digit percentage. There's an exciting case going through which goes to court on the 21st of June called Hurricane Energy that Emma mentioned. And there, the bondholders are converting their bonds or some of their bonds into equity to take 95% of the equity, leaving 5% for the shareholders. The shareholders have rejected the plan. They've said no. And the court will decide, and we would expect the court would agree, to force the shareholders to be diluted despite what they want. And that, for English purposes, is a major move forward unless you're a shareholder, obviously. And then Deep Ocean was the first plan where there was cross-class cram down. There, the company was being put into liquidation, but this was being used as a way to pay the money out, so as a tool. And it shows again the flexibility that Emma talked about in the courts. So then on to leaving restructuring plans behind, we can pick them up in questions if people want. Administration. Now, as Emma said, this is where, and I'll take this at a quick pace, building on what Emma said. The directors lose control. It goes across to the insolvency office holder, to the administrator. You can be appointed, he or she can be appointed in court by a judge or out of court simply by the filing of papers. So it can be done quickly and cheaply. And the moratorium, as Emma said, protects against enforcement against the company. Theoretically, the purpose of administration when it was first brought in 1986 was to rescue the company. And that's the primary concern, rescue the company as a going concern. But there's a waterfall, which is rescue the company. If you can't do that, then a better result for creditors. And that would typically be because in an administration, the administrator would trade the company on. You'd try and protect the going concern value. So administration idea is that the business trades on, and then the last is to realize property to distribute. Administrations have been have got most attention on what we call pre-packs. And a pre-pack is an insolvency where the business is sold out, typically on the same day that the appointment happens. The perception is that by going into insolvency, there is value destruction, people won't want to trade. So you prepare for the insolvency before, you file for insolvency and immediately sell the assets. So you've done the sale process in advance. And that has been a little bit controversial because it is open to abuse when the sale is sale back to the directors or back to the shareholders. So just a little bit on slide 15, a little bit just on when can an English process be used for a company, and conscious that this is where there's been some questions coming in already as well. Two questions about the English process and whom is it available to, and it needs to be thought both from will the English court accept jurisdiction, will they take jurisdiction, and secondly, a linked question is will the overseas courts recognise the English decision? The English, they're connected because the English court does not want to make an order unless it is likely that it is recognised. They both do not want to act in vain. What's the point of a court hearing if it won't be recognised in a place it needs to be? Also, they are concerned not to step on the toes of their fellow judges in other countries. So they don't want to impose their will on another country's regime unless that regime would be willing to recognise it. Now, the test for English jurisdictions, whether the court will take jurisdiction in England, is sufficient connection. That's the language. Those are the words that you would see in lots of cases, sufficient connection. And as the slide says, that's a very low bar. And it's a bar that if you haven't got it, you can make it. So the English courts are very, as Emma said, they've become increasingly pragmatic and restructuring focused. And they have expressly said that they are happy to accept good forum shopping. So they're happy for a company that has no connection to England. If the company, and typically the company and the creditors, if they wish to use an English process and to shop the forum to be able to come to England, as a general rule, the court will say that's okay. They have their antennae out, so they are very eyes open to abuse. They don't want that to happen. But particularly, as I said, where the majority creditors and the company wish something to happen, they think that's the best way to restructure, the English courts would accept it. They will want expert opinions from the countries which need to recognise the confirmation that that was the case. So we have their schemes and plans for recognition purposes are broadly the same in many ways. We've had recently Malaysian, Mauritius, that was the plan, Spanish and Dutch. The main European countries with companies that have come to the UK have been, as you see there, Spain, the Netherlands, and also Germany. We have had a French company with Zodiac, but only one of those, to be honest, which I think is because the French regime is actually a pretty good regime in many ways. How do you form sufficient connection, or how do you find it? English law debt, that's enough. So you can be a French company. If you have English law debt, the English court would take jurisdiction. Well, what if you have New York high yield bonds? Those aren't English law. Well, that's okay. The courts have said if the creditors wish to change the governing law to make it English, that gives you the English connection. So we had a number of companies where the law has been changed between the company and the creditors, or the lenders agree, give you English law, that gets you into England. The other thing you can do is to introduce a new co-obligor, or a new company in the group, an English company that agrees to guarantee the debt or become jointly liable as joint borrower. So depol is a regime whereby a company says, I will become liable for the debt. So we've had English companies in a group will say, I'm liable for that debt that's been borrowed by the French company. And then that English company comes into the process. It is highly artificial, and the courts have said that is correct. It is highly artificial. But if that's what people want, and if that's what the creditors and the company wants, then they're fine with that. And then the COMI shift, central main interest, if that's moved, by re-registering a company in England, by changing the board of directors to give them English-based directors, though they don't need to be English passports, but living in England. If they tell all their creditors that that's where the head office is now, and we had that particularly with some German and some Dutch companies, happens typically with holding companies where there are no assets other than the shares the company they own. But again, The shift, as they say there, is an artificial forum shopping regime, which courts are happy to accept in England. So very easy to come into England. You can make it if you don't have it. Recognition, on slide 17, this in reality is not an English law question. This is a question really for the local courts. So would a French court recognize the English decision? Would a Dutch court? Would an American court? And historically, we would have used the European insolvency regulation when we were much happier days when we were in the European Union. That would have afforded us the ability for recognition. It was a controversial question around schemes because schemes were not part of the insolvency regulation, but I won't go into that for the moment. Schemes, arrangement, and plans, though, will still most likely be recognised around Europe because of the Rome Convention, the point in the middle 3 green. And the Rome Convention relates to the governing law. So if it's English law debt that is being restructured, and I should say that we're mainly here talking about financial restructurings, not operational restructurings, where you're restructuring a bond or restructuring a banking facility. If it's English law that's being restructured through a scheme or a plan, generally, and it's a question for a French lawyer, for a German lawyer, but generally those would be recognised. If you don't have English law, well, you change it to English law and then you get it recognised. And that's a little bit more controversial, but if the majority of the creditors have changed the governing law, most debt documents would allow that to happen and it would then be recognised. So, I'm taking at some pace to conclude on slide 19 to allow us a bit of time for questions. So, historically, as Emma said, England was very creditor friendly. If you go back to the very old days before debtor's prison, Charles Dickens who wrote a lot of the English books, would write about debtor's prison. You go further back, people would lose parts of their body. You'd have your nose cut off or something. You might be sent to Australia if you were bankrupt as well. So historically, it's very creditor friendly, very contract friendly, but it has become increasingly restructuring and company friendly. The courts are very pragmatic and will try and help restructurings to happen. But you need to be aware, compared to France, we are still very unshareholder friendly. We follow the economics. When the value starts to break in the debt, the shareholders' interests become ignored. And with the advent of a restructuring plan, shareholders can be crammed down. Hurricane Energy will be the first example of that if that goes through next week. We have developed over the last 20 years, particularly over the last 5-10 years, like many of the European jurisdictions, we've developed some really good restructuring tools. Now, one of the questions that came in was around the restructuring directive in the EU, which I think is a marvellous piece of legislation. Really, I mean, the committee that put that together really deserves a lot of credit. It's really a very impressive piece of legislation. We, unfortunately, are no longer bound by it. So we no longer will have to formally follow it, but informally, I think we will. The Conservative government, when they came in, said they wanted to try and improve the restructuring regime to bring us up in the World Bank sort of league table of restructuring regimes. We had been falling down to the mid-teens, and they wanted to bring us up towards the top sort of half a dozen. Now, to do that, we basically have to follow concepts of debtor in possession, pre-insolvency procedures, cross-class crown down. All of those things will be good for elevating us up through the World Bank table, which effectively means that informally, we will be looking across at the European Restructuring Directive and seeking to follow it. But it's an informal, not a formal approach. We, of course, also have the advantage of, in reality, it's not really English, to be honest, it's really American is the important point, because so much capital comes from the US, and then the hedge funds are often US-based or have US people, and therefore a lot of the creditors are happier using English/American, hence why the English courts are more attractive for them than some places. And as a result of all that, we have the benefit of a long history of restructurings, and that gives a greater degree of deal certainty. People know roughly what the courts will do because they've seen it done before, and that's very helpful. And as I said, restructuring plans are good because they're building on the old regime. And then lastly, to say, we don't have debtor in possession financing, but generally there are ways to work around that. And that's one of the reasons why we're not too high in there. So with that, we'll finish the formal bit. I think I've answered the questions around the restructuring directive. And then in terms of being recognised around Europe, I think I hopefully answered that in terms of Rome Convention really being the case. So thank you.
Thank you very much, Richard and Emma. That was fascinating. I've got a couple more questions here. One question regarding the post-Brexit scenario for the UK, and taking into account that the UK is not using the Lugano Convention. What can the UK do to make its restructurings recognised internationally, particularly in Europe?
Emma, do you want to take that, or?
Yeah, can do. I mean, it is still open for the UK, I think, to join in theory the Lugano Convention. But as Richard has said, there is still very much an ability for foreign companies to restructure in the UK, especially when you're talking about English law debt, and there's the ability to change the debt to make it English law. And therefore, whilst we lose some of the recognition means like the judgments regulation post-Brexit, there are other ways of achieving the same recognition.
So we had the Gate Group had a Swiss law bond, and they went through a restructuring plan earlier this year. And there they had expert opinions from Swiss lawyers and from Luxembourg lawyers, so Switzerland being outside the EU, but Luxembourg being in it, where they said that Gate Group would be recognised. So it is a work stream on a restructuring. It's a work stream to be looked at. But again, particularly if you have the creditor supporting, then you can kind of reverse out of recognition by maybe a change of governing law, for example. It is harder, to be fair. I mean, it certainly is not as easy as it was when we were in the European Union, but there are kind of workarounds on it.
Another question. Are there any restrictions on a shareholder acting as a normal creditor in a scheme or a plan or a CVA where there is voting on the value of the debt?
Shall I take that one?
In other words, can a shareholder who has 75% of the debt impose a solution on the other creditors?
Yes is the answer, but it's a little more complicated than that. So there's no equitable subordination in the UK. So shareholders can hold debt and it can rank pari passu with other creditors of the same ranking. So we're not like, take Spain or Germany, or to a certain extent, France times. So when you're looking at the vote, the 75% vote, the shareholder debt will vote alongside and will count for that 75% for a scheme and for a plan. And Emma mentioned that on a plan, there's no connected party issue. So the connected party is like a shareholder who has a connection. So they vote yes. But when you get to court, if you remember I said the third green light was fairness, then the court will look very hard if the vote has been carried by the shareholder vote. So if, for example, the shareholder is a creditor and the vote was to zero the debt and leave all the value with the equity with the shareholder, the court would not accept that. They'd say that's not fair. So that it's yes to the vote for the percentage, but you then need to look at the fairness on it.
Okay. Very good. Well, thank you very much, Richard and Emma. I think we've now reached the appointed hour, so we will let you all go and have your lunch. Thank you very much to everyone for listening to the first TMA talk in English. For the members of TMA France, we have a networking session with the members of TMA UK next Tuesday, which I'd encourage you all to sign up for. And I wish you all a very good afternoon. Thank you.
Thank you very much.
Thank you very much. Au revoir.
Au revoir.
Des gens qui vont venir de domaines différents, on va avoir des avocats, on va avoir des spécialistes de la restructuration, on va avoir des financiers, et tous ces gens-là sont en train de construire quelque chose qui n'existe pas aujourd'hui.
Avec cette association internationale qui crée le chapter France, on va pouvoir échanger entre professionnels du restructuring. Et puis on va pouvoir partager des bonnes pratiques.
On est vraiment dans une association qui comble un besoin. Je pense qu'on aura du succès, donc on va voir ça dans les jours et mois qui viennent. Et on espère que tout le monde va suivre le mouvement et notamment tous les professionnels du secteur pour faire de cette association une réussite.